Good evening, ladies and gentlemen. I hope you can hear me clearly. I'll try and place the microphone so that there's no difficulty. Honorable judges and distinguished ladies and gentlemen, it's an honor to have been invited to moderate this very distinguished panel of speakers. We've agreed to adopt in this session an informal question and answer style, and we will be remaining in our seated positions with no disrespect meant to the eminent speakers. We thought that this would be a more lively and engaging style to take late in the day on a Sunday. Our theme for this session is Resolution to Revenue, How ADR Shapes Foreign Direct Investment. And during the discussions over the course of this weekend, there have been several references to the potential interaction between ADR and FDI, and also mentioned during the course of the discussions, LDI, local direct investment. In this panel, we're going to take a deeper look at the subject and examine in more detail the link between ADR and FDI. We'll consider a number of matters. First, the availability of dispute resolution mechanisms and its effect on the appetite of investors. Second, the impact of the processes and procedures of dispute resolution on their appetite. And third, the projects and the fiscal framework for those projects into which investment is made and its effect on investment appetite. Now, this is a controversial subject. One may contrast, for example, in 2018, Doctors Frenkel and Walter published a report in the World Economy Journal which found that ISDS provisions in bilateral investment treaties have a direct effect to promote FDI in the jurisdictions which are parties. However, in 2022, in the British Journal of Political Science, Messrs. Kerner and Christoph found that ISDS provisions on dispute resolution make little or no difference to the appetite of investors for FDI, even when the state has a track record of contesting and losing ISDS claims. It has little impact. At the same time, the number of investment treaty cases which are brought is growing all the time. Since the UNCITRAL Working Group 3 sessions began in 2017, up till last year, 442 ISDS cases were started, in 29 of which the damages demanded were in excess of $1 billion. We've also seen states in Central America and Africa in particular announcing their intention to withdraw from BITs or to make new BITs which offer, they would say, a more balanced protection for investors and protection of the state's rights to regulate and legislate. I'm going to briefly introduce our speakers, if I may. I can't do justice to all of their achievements in just a few minutes. Starting on my far left with the Honourable Mr. Justice Yusuf Ali Saeed, who is an additional judge of the Sindh High Court and is the designated monitoring judge of District Saeed Benazirabad. He studied both in Pakistan and in England, and he practiced as an advocate before the High Court and the Supreme Court as a civil litigator. He's both been a lecturer at SM Law College and Hamdard Law University, and he's served on the appellate and election tribunals. He's also a member of the Information Technology Committee of the Court, and so has one eye firmly on the future. Secondly, Mr. Kevin Nash in the middle is the Registrar of the Singapore International Arbitration Centre. He leads the SIAC Secretariat in the provision of case management services. He's overseen the administration of thousands of international arbitration cases under the SIAC rules and also under the UNCITRAL arbitration rules. He has participated in both UNCITRAL Working Group 2 on dispute settlement and 3 on ISDS, and he's spoken and lectured on several contemporary issues in international arbitration at events all over the world. He's described in one of the directories I noticed as a rock star of arbitration, so I'm hoping he's going to play some of his hits for us today. Next to me is Shabakt Pizada. He is a partner at Riyad Barker Gillette, a leading law firm here in Pakistan, as you will all know. He specializes in advising representing clients in complex commercial disputes, often across multiple jurisdictions. He's assisted several international arbitration tribunals and courts in addressing questions of Pakistani law. His clients include leading companies in the oil and gas, power, shipping, insurance, and financial services sector. And last, but very much not least, is Hassan Manviwala. Hassan is a commercial and disputes lawyer at Manviwala and Zafar here in Karachi. He's an English law graduate. He has qualified both as a solicitor in England and as a barrister of Lincoln's Inn. He is the national representative for Pakistan for the IBA, and he occupies a position as the officer of the Anti-Money Laundering Committee of the IBA and the Young Lawyers Committee. He's recently spoken at the IBA Distribution and Supply Chain Conference in Washington, D.C., and before the Senate Standing Committee for Revenue and Finance in Islamabad. I'm going to start, if I may, by asking Justice Saeed to address us first. Justice Saeed, if I could ask you to turn your mind first to the question of ADR and FDI from a judicial perspective. In your mind, what are the things that you see a government such as Pakistan can concentrate on in addressing the relationship between ADR and FDI by supporting ADR in the courts? Can I now, by reference to one particular protection offered to investors under bilateral investment treaties, just ask Hassan to come in on a subject that you offered to mention when we were preparing for this session. One of the major protections that one sees in treaties, and sometimes in contractual agreements, is an agreement not to restrict the repatriation of profits or assets in any way, to allow an investor freely to take out any proceeds of its investments. Hassan, can you say a word about how in Pakistan foreign exchange control and the removal of profits is policed, and whether protections given to investors can be difficult to enforce in that area?